This is Michael Popok, Legal AF After Dark. We had a lot of developments in Donald Trump's attempt to use immunity or double jeopardy or the impeachment clause or the kitchen sink to try to overcome his indictment in the District of Columbia pending with the D.C. Court of Appeals. We got full briefing now. We got the brief by Jack Smith. We got the brief by Donald Trump, the reply brief or whatever you call it, in which he cites his own made-up fabricated evidence of voter fraud in his reply brief. Is that okay or not? That seems strange. In addition, there's a number of other friends of the court who have filed briefs that have gotten the District of Columbia's attention. Particularly, one friend of the court, or amicus brief, filed in which the argument is that there is no jurisdiction, that there can be no appeal at this moment by Donald Trump. He's got to wait till the end of the trial and see if he's convicted or not. And the D.C. Court of Appeals wants to hear about it. Karen Friedman Agnifilo on one side, me on the other. We debated all on Legal AF, and here's a clip. Okay, let's dive into...
Yeah, where are we going first, Popok? What do you want to talk about first?
I think I want to talk about Trump and immunity. I'm kind of, not that there's a priority here, but I think that's the one people are most interested in right now. I'm going to frame it and I'm going to kick it over to you. You've got the argument, as I think ill-conceived as it is, that Donald Trump can do, any president, according to Donald Trump, as long as he's wearing the cloak of being president and has some sort of nexus with quote-unquote official duties of the president, can get away with murder. There's no other way to put it. I mean, I saw some writing today, including one of his former lawyers commenting to take Donald Trump not even to a ridiculous extension of his argument. His argument is that Joe Biden, currently the president, could kidnap Donald Trump and whisk him away to some lair and or, you know, do something bodily injury to him. And it's all okay as long as there's some sort of connective tissue between, you know, Donald Trump and the official actions of the president. That can't be the law. I don't want to live. Let me put it this way. I don't want to live in a country, in a constitutional republic where that is the law. And I don't think the justices of the D.C. Court of Appeals, nor the majority of the U.S. Supreme Court, want to live in that world either. And so the way the issue's been framed now, we have a fully briefed issue. And when I say a fully briefed issue, a little breakout, we'll have a couple of breakout sessions of Legal AF Law School tonight on appellate practice. A fully briefed issue is the person who's taking the appeal, and that's Donald Trump. He lost at the trial level to Judge Chutkan. Judge Chutkan, the trial court judge who was presiding over the case, the trial is going to hopefully going to trial in March or sometime thereafter on 4 conspiracy counts against Donald Trump only in the District of Columbia. She ruled on a motion to dismiss that was filed by Donald Trump that he does not have any kind of absolute constitutional presidential immunity against the criminal indictment to have it dismissed before trial. No way, no how. That is up on appeal because Donald Trump filed an appeal. He gets, because he's filing the appeal, or anybody that files the appeal, they're known as the appellant, they get 2 briefs. And it might seem unfair, but that's the way it works. Whoever brings the motion or the appeal usually gets 2 briefs. The opening brief, the initial brief, whatever, the appellant's brief in this case. Then there's a brief in the middle, which is the opposition paper. That's by the Special Counsel, Department of Justice. And then you have, so that's the appellee's brief. And then there's a reply brief. Now, that's all been briefed, except in the last week, we've had Jack Smith file the opposition brief. We'll talk about that. And Donald Trump file a laughable, I think, something that could be stricken from the record if Jack Smith wanted to do that, ridiculous reply brief. The reply brief, I'll start backwards. The reply brief by Donald Trump is not supposed to introduce new evidence. It's not supposed to introduce things that weren't in the record below. It's not supposed to introduce made up, fabricated legal authority that Donald Trump himself posted on social media a day before he filed the brief, yet cites it twice in the brief. Aha, there's fraud in elections. And what does he cite for that? Donald Trump on fraud in elections. A 32-page, there it is, 32-page, anonymously, not signed piece of you-know-what that has been, all of the allegations of voter fraud, he says, are in there. He says these are top election officials. They're so top election officials, none of them wanted to sign their name to this. And it's every debunked and rejected and investigated and rejected allegation of voter fraud out there, all stitched together in one place. It's like if Mike Lindell, the pillow guy, Sidney Powell at her height, and all the other crazies got together and wrote a brief. And Donald Trump cites it in his own, or his lawyers do, in their own reply paper. I'm going to make a declaration right here. I'm going to draw the line in the sand. Every allegation that Donald Trump makes in that brief, that there was voter fraud in the 7 swing states or the battleground states, has been completely debunked and rejected by federal courts in 62 cases, state and federal, by every state, every secretary of state of every state that's evaluated in those 7 battleground states. The FBI, the bureaus of investigation of every state that I've just talked about, the head of cybersecurity and election integrity for the United States, the Department of Justice, then under Donald Trump, all Donald Trump's own fraud experts that he hired as consultants and paid millions of dollars to, all have rejected everything in that 32 pages.
But I have a question, Popok,
sure, yet it
about
finds
that.
its way into the third. Yet it finds its way into the reply paper. That is the final word for Donald Trump. I think it pisses off the 3-judge panel that's going to be heard on January 9th. I think it annoys them and demonstrates that the emperor, in this case, Trump, as disgusting as this might sound, has no clothes.
So, well, especially now that we know those other facts about him, you know. So I have a question though. How do lawyers like Todd Blanche and John Lauro, who used to be, I mean, they're lawyers. They're not like Alina Habba or, you know, what's her name, Team Crazy. For some reason, I'm blanking on her name. The one who pled guilty.
Powell.
Yes, yeah. Sidney Powell, Rudy Giuliani.
Yeah.
Do you know what I'm saying? Like John Lauro and Todd Blanche were respected lawyers, and even if you disagree with who they're representing, how could they put that in the reply brief? And that's what the question I want you to sort of theorize about, because you and I both have had difficult clients. We have had clients who've wanted us to do things that go against our ethics, that we won't do. And there are ways to do it, right? If you're forced to do it, you do it in a way that you're signaling that the client, you know, you're not throwing them under the bus, but you're also sort of distancing yourself and disavowing. You're not adopting the crazy. What is your theory as to why John Lauro and Todd Blanche would include that ridiculous 30-something page set of non-facts?
Self-created, self-fabricated, self-serving piece of self. Let me try it this way. I totally agree. It's a great question. I totally agree with you. I've been trying to watch these people that used to have a shred of dignity and professionalism and watch it all disappear and wonder why. Because you and I have fired clients. I know it without even asking you. I know that you have, who have asked you to do things that are unethical or to take positions in the filings or papers that you know to be untrue. First of all, you're an officer of the court. You are an officer of the court. I'm talking to you, Lauro, Blanche, Keiss, forget Habba. You have an obligation to be forthright, diligent in your positions, inform the court of countervailing arguments, even if they, of course, go against you, and the like. You took an oath, both when you became a member of the bar and again, the member of the federal court or appellate court in which you are in. The fact that I can tell you right off, Lauro, the number 1 client in the firm right now generating dollars for Lauro is Donald Trump. Chris Keiss literally left a large major firm here in New York, no, in Florida, to serve 1 client, Donald Trump. And he's gotten millions and millions of dollars in the last 2 years. We know it's been publicly reported. And Todd Blanche did the same thing. Todd Blanche left a major firm and opened up his shop with 1 client, Donald Trump. Now, they're either true believers, in other words, from a political MAGA standpoint, because I can't believe that the Donald Trump is so captivating and so magnetic that they just, whatever he says, I'll do. It has to be the almighty buck. It has to be that they are willing to sacrifice on the altar of greed their professional ethics in order to make Donald Trump happy. Because if you and I in the middle of the night and writing a brief got delivered to us from Donald Trump, right? From Boris Epstein, let's say, who works closely with Donald Trump and is the puppet master for some of these lawyers. It says, here you go. We just got it. You and I looked at it. We're like, oh, let me see what this is. This might be good for us. Let me take a look. Okay. Who wrote it? We can't reveal that. Well, what's it based on? A whole bunch of news articles and MAGA and thrown in there for a good measure is a whole bunch of QAnon stuff. And all of it's been rejected. And what do you want me to do with it? I want you to cite it in the brief. You and I would go, no effing way. You write it. Don't put my name on it. That's what lawyers do. Especially when there's multiple lawyers. Like, don't put my name on that. Because by signing that brief, you're saying that you're making a good faith legal argument. And you can be sanctioned by the court or referred to the bar. So I think it goes beyond pissing off the 3-judge panel, which they're going to piss off. I think it's going to be Judge Pan as the chief judge for the 3-judge panel. She's going to be pissed off by these citations. And wait, you and I are going to be just biting our lips with laughter watching the oral argument on this one. What's your theory? Why have they written including new evidence, new non-evidence, making arguments they shouldn't be making in a reply brief? Why are they doing that? Why do you think?
Well, so those are two different questions, right? I think they're just throwing the kitchen sink in there and everything else because they're not really playing to the audience of the appellate courts. They're just putting everything out there for the Supreme Court and for the court of public opinion, right? Because that's their ultimate audiences. They know they're going to the Supreme Court, and so they're getting it all out there now. And I think they're test driving certain arguments and seeing what works in the courts and what doesn't, what works in the court of public opinion and what doesn't, and then they can refine them when they get to the Supreme Court. I think at a certain point when you know you've lost already and you have nothing to lose, then you're not going to do anything other than just throw I've been calling these Hail Mary approaches to practicing law, where you just throw everything in and you go for it and you see how it works, you see what sticks. And I also think Donald Trump has a way of just repeating claims that are false, and somehow they become true. And that's something I think about a lot, because when I talk to people who I'm either friendly with or family members who are on the right side of things, they will often spew these nuggets of facts, or I should say facts with air quotes, that it's just recycling things that Trump is saying, and they don't do any analysis. They just sort of hear it over and over again, and then they start hearing it from different people, because then you get the Fox News people repeating the same thing, and you get the Tucker Carlson and Sean Hannity and whoever else you get out there who start to rinse and repeat these ridiculous arguments, and suddenly they're facts. Well, people are saying them, so more than one person is saying them. So I think that's part of it, is this echo chamber of information, and they're just all in. They've decided to go all in with Trump because it otherwise makes no sense, because they've kind of decided that he's their guy, and they're all in, and hopefully he'll win. And then anything that happened to them, their ticket is punched and they're golden, right? Nothing will happen to them. So I think
except I'm sure all the other lawyers, like all the ones that have been indicted and or lost their law licenses, felt the same way. I mean, this is not the varsity. This is not the junior varsity. This is like the freshman team. This is what's left of the lawyers that are willing to represent Donald Trump. As I said in prior hot takes, there are amazing law firms in this country. Some of them even reach the level of the top 200. This is not the top of the class here. All the lawyers that we've seen that have entered appearances here, I'm sorry, they're just not at the creme de la creme of they don't match the lawyering on the Department of Justice side, and they don't match the jurisprudence or of the judges and their backgrounds and experience. It's a mismatch of epic proportion. I don't think, let me ask you something. I've always said this about the immunity argument. And the argument is that they're under a series of cases, including one that came, I want you to talk about one that came out of the Manhattan District Attorney's Office. Because if you had to just strip away all the cases, there's really 3 or 4 cases that all the parties are relying on in front of the District Court of Appeals. It's the Clinton Paula Jones case, which is a civil case. It's the Nixon v. Fitzgerald case. And it's the Trump versus Cy Vance case. And they're all aiming, not for the DC Court of Appeals, but both Jack Smith and Donald Trump are aiming for a higher authority. And they're trying to find their 5th vote at the Supreme Court level. And Kavanaugh, who wrote a lot in the Cy Vance, but I think really on balance against Donald Trump's position. There's snippets here and there. If you take them out of context, it looks like maybe Kavanaugh would support establishing a rule that there is absolute immunity for anybody that served in office against any crime that they may have committed while they served in office, because that's what the framers of the Constitution wanted. But that's what they're aiming for. They're trying to collect votes. They need 5 votes at the Supreme Court level. And John Roberts is going to struggle to find his 5 votes to not establish that precedent if they even decide to take the case. The easiest thing for the Supreme Court is let the DC Court of Appeals make their ruling 2 or 3 days after the oral argument. It's a very good panel. Judge Pan knows what she's doing. So does Judge Childs, the other one too. And they make their ruling. And they're going to rule against Donald Trump. I mean, no spoiler alert here. They're ruling against Donald Trump. If Donald Trump really believed he had, I'm going to do it this way, temporally. If Donald Trump really believed he had a compelling argument, he would have raised it when the indictment came out against him by the grand jury, because nothing in his motion papers or his appeal has anything to do with the documents and discovery produced by the government against him. It all has to do with the 4 corners of the face of the indictment. That indictment is a year old. If he wanted to actually have it, he thought he really had a great argument, you would have done it the day after the indictment or a week later, not a year later. The only reason you waited a year is because you know it's a BS argument, but you're using it to throw sand in the gears to avoid the March trial so you can get to the November election. That's it. If you and I represented Donald Trump, God forbid, I don't even know what to cross because that's not my faith, but if you and I represented Donald Trump, right?
You don't make an X, Popok. Right. I can tell you that.
Whatever this is. I feel like Joe Biden. I love when Joe Biden uses his faith. But we did, okay? We would look at the indictment. If we thought we had an immunity argument, you and I would file that within a month of the indictment. The reason he's waited till now is not because it just dawned on the lawyers they should get around to doing it, or it took a year to research. Obviously, what they've written it takes about an hour to research. It's because they know they're going to lose. And as you said, this is all being tried not in the courtroom where they know they're going to lose, but in the court of public opinion, public fundraising, and to try to get to the election in November. This is just trying to get to the finish line and outrace all of these suits by Donald Trump to get to that's why he's running. This guy didn't want to run for president the first time. The only reason he's running for president the second time is because he wants to avoid, if he can, a conviction or sentencing. That's it. That's the only reason.
Getting back to what you were saying, though, about this being a reply brief and you're only supposed to reply to the issues that Jack Smith raised in his opposition to your appeal. What I found most interesting about this, and I want you, if you can, speak to it, because I'm still trying to wrap my head around the argument, to be honest. Under the theory, you open with your strongest argument, you want to kind of put your best foot forward, et cetera. I found it interesting that they opened on this reply brief with a totally new issue that seems to have been missed by Jack Smith. It seems to have been missed by all the legal experts and people who were commenting. And I think it was raised in an amicus brief where they were talking about this case, Midland Asphalt, which basically says that it has to do with whether or not they can do this interlocutory appeal, this there's two ways to appeal, right? There's you get convicted and you appeal after the fact the way everybody else does. But there are a few issues that you can appeal midstream. And essentially, Jack Smith all but conceded that you can that this case will be stayed. We can press pause, and that we're going to go forward. But I'm not sure that, and I think that worried Trump, and so that's why they came out kind of arguing this brand new issue that I'm not sure is really 100% frivolous. I don't know. And I just wondered, how did everyone miss this argument, right? And why not at least make it? I just thought it was sort of strange that Trump felt the need. Of course, he had to address it because it's in one of these amicus briefs, but the fact that it was first, I thought was sort of interesting. Do you make anything of that?
Yeah, I do. Well, first of all, the DC Court of Appeals has told the parties they need to be prepared to address at least 2 or 3 of the amicus brief, the friend of the court briefs that have been filed. One of them, my senior partner here at my law firm, Nicholas Rostow, signed off on. I'm proud of that. It's the Article 2 argument that whether there's immunity or not, it certainly wouldn't be a president at the time interfering with the second with the Article 2's peaceful transfer from one administration to the other. That wouldn't be the one that you would do. But the one you're talking about, I liked as well. That was raised by another series of lawyers, including Ty Cobb, that used to work for Donald Trump directly, in which they argued that when the framers of the Constitution wanted to immunize a federal officer, they knew how to pick up their quill pen and write it into the parchment. They knew how to immunize by using actual language that they wrote in. And they use as an example that there are basically only 2 actual immunities that stop a lawsuit stop a prosecution in its tracks at the indictment stage, even without trial. There's only 2, according to this analysis, which I thought was a good one. And so good that the Court of Appeals said, that's interesting. We want to hear about that. It's very similar, Karen, if you remember, we'll talk about it later too, where the 11th Circuit, in deciding whether federal removal was available to a former federal officer to take the case from Georgia State Court indictment to federal court for Mark Meadows and others, whether it applied to former federal officers, the operative word being former. No one had briefed that. No one had argued that. In fact, in 190 years, there hadn't been any jurisprudence or precedent about whether it applies to a former federal officer. Not only did that become a key issue, it's the grounds upon which Chief Judge Pryor in the Meadows case ruled. And they told the lawyers on either side to be prepared to talk about this former thing too. Now, here.
But aren't you prepared? Aren't you surprised that Smith missed it?
I don't,
why did it have to come from Ty Cobb? No offense to Ty Cobb.
So let me finish the argument, and I'll come back to the myths. I agree. Yeah, the argument is there's only 2 types of immunity that are written into the Constitution that stop an indictment in its tracks. One is speech and debate clause immunity, which is you are a member of the House or Senate, and you're doing your job within the scope of your job. You're not interfering with elections like Lindsey Graham, but you're doing your job, fact-finding, legislative work and reports and hearings and making laws. Whatever you do there, even if it would be a crime for somebody else, is not a crime for you. You get immunized because that's in the Constitution specifically. That's one. And then what's the second one? Do you remember the second one, Karen? I'm doing it off the top of my head. There's a second one that'll come to me before.
Separation of powers?
Is that the separation? No, it's not the separation of powers, because that's one of the ones they're arguing here. It'll come to me. It's the second one. And that's it. And the one that this made up presidential immunity, which is nowhere, I want to repeat this, nowhere in the Constitution. And we can take time out of this show and everybody can go read it. Nowhere in the Constitution, it's not by accident, is there a section called the President of the United States at the time will be immune from any civil or criminal action while he was in office, regardless. It's not in there. It comes from case made precedent that's been made about the separation of powers and the presidency and all of that. But that's where it comes from. It comes from the Supreme Court and other courts applying it, not because it's in there. And that's the point of the brief you're talking about. That was this amicus brief, which is there's no even jurisdiction. I mean, on this particular issue, we shouldn't even be there. There is nothing to talk about. First of all, there's no interlocutory appeal on this issue because you shouldn't be discussing this issue at the indictment stage. He should be tried. If he's convicted and sentenced, we can go and figure out whether he had presidential immunity. It's sort of a strange argument. Whether Jack Smith missed it or not, or just in the course of you've only got X amount of pages to make your lead arguments. As you said, you prioritize your arguments. You don't throw every argument at, and I'm assuming, I could be wrong, but I have a lot of respect for Jack Smith in the office. They looked at the issue about
double
whether
jeopardy?
Yes, it's double jeopardy. Thank you. Very good. So double jeopardy and speech and debate.
By the way, I'm not going to take credit. Someone in the chat just said it. I'm not going to try to take credit.
Who said it in the chat? I'm going to call them out.
A few different people said it, actually. They're like, Popok, it's double jeopardy. So hold on.
Thank you.
Yeah, no, I love the live chat. I'm looking at it.
We're
They're
all
like,
in this together. That's awesome. I just couldn't.
Let's see. Omno
Can
Storm.
anybody see my notes? If you can really. And I did a hot take on it, no less.
Omno Storm said it.
Good.
And Vito Bardo said it.
Yeah.
So those are
Salty.
the two.
What do we have for them? More show. That's what you get. Well, welcome back. If you like lawyers who know what they're talking about at the intersection of law, politics, and justice, you came to the right place. Legal AF, one place exclusively. Don't change that channel. It's the MeidasTouch YouTube channel. And if you free subscribe and help them get to 2 million, your voice will be heard. It's a grassroots without outside investor network. It is the network on social media that you've been looking for. So if you know about Legal AF and already, Ben Meisalas and me on Saturdays, Karen Friedman Agnifilo and me on Wednesdays, welcome back. Thank you for being on our journey. If you have no idea what I'm talking about, that was Legal AF. I'm Michael Popok, and you could use that clip and send it off to other people, friends and family, and ask them to join our rides Wednesdays and Saturdays, 8 p.m. Eastern Time on YouTube, and then on audio podcast platforms of your choice. So until my next Legal AF and my next hot take, this is Michael Popok reporting.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.